Hello and welcome to The Bridge. India's regulators affect markets, govern disputes, and test the rule of law through their orders, regulations, and policy implementation actions. Yet, the quality of this work rarely gets the scrutiny it deserves. The Bridge is TrustBridge's window into India's regulatory state, how it decides, how it regulates, and how it could do both better. Here are some of the interesting and useful things that we've been thinking about this past July. Number 1. What even is fraud? On the 29th of May this year, the Supreme Court issued its judgment in Reliance Industries Limited versus the Securities and Exchange Board of India. This decision clarifies the long-standing ambiguity in what fraud means in Indian securities law. We unpacked this clarification and considered how SEBI is putting it into operation and what still remains to be done. Number 2. What isn't upheld gives you feedback. When a regulator's adjudicatory order is overturned in appeal, what the regulator gets from it is feedback. We've been collecting SEBI orders that have been appealed to the SAT and then eventually to the Supreme Court in order to systematically gather points of feedback for SEBI's adjudicatory process. We started with the famous PC Jewelers insider trading matter and found that, just as we expected, the Supreme Court's judgment is full of useful advice for SEBI. Number 3. This communication should have been an order. Intuitively, when a regulator passes an order that negatively affects someone's rights, the affected person deserves to know why. All orders must be reasoned to be legitimate. But does it matter whether we call the instrument involved something other than an order? Does the label affect the right to reasons? The SAT order in Marwari Chandrana Intermediaries Brokers Limited versus SEBI seems to suggest that it might. A company's request to withdraw an open offer was rejected through a SEBI communication devoid of reasoning. When the communication was appealed at the SAT held that SEBI had to convey its decision with reasons because the communication was akin to an order. We examined this matter to consider whether the instrument SEBI uses should affect its obligation to give reasons at all. Number 4. Our 2 cents on the Securities Markets Code Bill. In December 2025, the Ministry of Finance introduced the Securities Market Code Bill 2025 in the Lok Sabha. The bill was subsequently referred to a Parliamentary Standing Committee on Finance. The committee invited comments and some of us sent them our thoughts. We're very excited to share that a few of our comments were even accepted by the committee. Number 5. We have that order that you're looking for. Regulators with adjudicatory powers pass hundreds, if not thousands of orders each year, which are then appealed to tribunals and the Supreme Court. Despite the volume, or perhaps because of it, there is no consolidated, publicly available database of regulatory and appellate orders. To solve this problem, we've created the TrustBridge Regulatory Database, a single interface to access every adjudicatory order passed by SEBI, the CCI, PNGRB, along with orders and judgments of the SAT and the Supreme Court, with more regulators and tribunals to come in the next few weeks. We're pleased to announce that the database is now live and will be publicly accessible soon. Keep an eye on this space. We'll have that order that you're looking for shortly. To read these pieces and more, check out The Bridge, linked in the comments. And finally, one interesting regulatory development this month. The TNERC is a very lonely place these days. And that's because since the 25th of June 2026, the Tamil Nadu Electricity Regulatory Commission has 0 incumbent members, adding to the mounting problem of vacancies at regulators. At TrustBridge, we're tracking the regulatory vacancies problem closely. Stay tuned for updates on our work on this. Thank you for watching and see you in the next one.